today we're going to focus on commonly filed claims regarding FDCPA. What are the top 10 allegations throughout the country? So for those of you who may not be aware of what the FDCPA is, its full name is the Fair Debt Collection Practices Act, as you'll see on this slide. It's a statute that's now about 40 to 50 years old, so compared to all the other regulatory statutes, it's not quite that old, and it's not quite new either. It's a relatively simple statute with many different subsections that we'll go over, but it's hard to define, or it's hard to understand. It's simple to read, but harder to understand, implement, and litigate, because its terms are constantly subject to ever-changing interpretations by the courts. So the FDCPA was passed to eliminate abusive collection practices. It's really targeted at those collectors who they, for lack of a better term, are called fly-by-night. They don't have processes in place. That's how it was that was the purpose when it first started, but it has now mushroomed and expanded to cover everyone in the debt in business and loan servicing industry. And even though you have systems and policies in place to protect yourselves, and which you should, you will frequently find yourself to be a target of lawsuits involving this act. So who is affected by the FDCPA? As I said, debt collectors are affected by the FDCPA. Those who do loan servicing are also affected by the FDCPA. It really covers a wide range of entities who are in the debt business. The one exception are creditors. So they are not subject to the FDCPA, although they may still be susceptible to claims under state consumer protection laws, the Dodd-Frank Act, and also portions of the FTC. So I mentioned earlier that the FDCPA has many subsections. And we'll go over them in a little bit just to give you an overview. Who can sue under the FDCPA? It's basically any person, so even a non-consumer, for various debt collection practices. Even third parties can sue for an FDCPA violation. Although there are specific sections of the FDCPA can only be brought by the consumer itself, and we list them down for you here. It's 1692C, 1692E, which is commonly known as the false or misleading representation subsection, or 1692G, which involves validation rights. Today we're just giving you a quick overview. What are the damages? Why has this particular statute mushroomed over the years, when you could clearly see here statutory damages are only limited to $1,000 for statutory violations for an individual. So what does that mean? Sometimes you'll get a complaint where it lists 15 different violations of the FDCPA. It's not an award of $1,000 per violation. It's $1,000 maximum for all of the alleged violations individually. And I'm just talking about statutory damages. A plaintiff is also entitled to actual damages. For example, emotional damages if they can prove it, and also, let's say, if the underlying debt was not authorized for collection and the court determines that, maybe any fees that they have paid with respect to that debt may be refunded back to them. For class action cases, the statutory damages are capped at the lesser of $500,000 or 1% of a debt collector's net worth. So what does that mean? So if you are worth $15 million, 1% would be $150,000. That's the lesser of $500,000. So the statutory damages are capped at $150,000 plus attorney's fees and costs of the plaintiff if they prevail. So those are the damages, and I believe we can now move on to our first specific topic to address today in terms of FDCPA violations, and that's the failure to provide a mini-Miranda warning, and I turn it over to Barbara.
Thanks, Connie. So our number one in our list of 10 top violations is failure to provide mini-Miranda. We don't see this as much anymore because of the fact that I think most debt collectors are familiar with the statute enough to know that this needs to be required. But we're going to cover it anyway because we do still see it, and it is definitely a violation if it's not included. It comes from Section 1692E11 of the FDCPA, which states that in the initial communication to a consumer when collecting a debt, what we call and what the industry calls the mini-Miranda must be included, which is this is an attempt to collect a debt and any information obtained will be used for that purpose. The industry calls it the mini-Miranda because it's basically a warning to the consumer that this is a debt collector and we're attempting to collect a debt, and letting you know that any information will be used for that purpose. Failure to put this in your initial communication would be a violation of 1692E11. Now, the mini-Miranda, like we said, must be given with every initial communication with the debtor. However, what the statute says is that in every subsequent communication, the collector must only state that the communication is from a debt collector. They don't need to actually reassert the mini-Miranda, but the subsequent letters must only state that the communication is from a debt collector. And one thing to keep in mind is that Section 1692E11 only applies to consumers. Since 1692E as the provision as a whole only refers to consumers. Strike that. Let me take that back. That Section 11, the way it reads, the way it's worded, refers to consumers. So courts have interpreted that because the actual provision of E11 refers to consumers, then it only applies to consumers. Now, why is that important? Sometimes these letters go out incorrectly. They might be mailed to the wrong individual. So in the past, there have been the individuals as non-debtors who receive these letters have tried to actually sue on the letter, even though they're not the debtor. Well, courts such as Sclafani, that's cited in our PowerPoint, which is a Southern District of Florida case, says that a non-debtor cannot sue for not receiving a mini-Miranda since, again, they're not a consumer. There's an exception to 1692E11, which is expressly stated within the statute, which says that the mini-Miranda in that section shall not apply to a formal pleading made in connection with a legal action. Well, as you can imagine, there's been a lot of litigation as to what is a quote-unquote formal pleading. There is a particular case in the 11th Circuit called Milkovich. It came down in 2015. The site is 791 Fed 3rd 1291. And in that case, what the court said was, and what they did is that they did strict compliance, which is what they're usually supposed to do with statutes. They did a strict compliance analysis of the statute, and what they came up with is that because the statute actually says and carves out formal pleadings, the court looked at what is a formal pleading in the Black's Law Dictionary, in the legal dictionary, and formal pleadings for the most part, is the complaint and the answer. So what did that leave? Well, that left an open-ended question as to what other documents that are being filed in court constitute formal pleading, and do they require the Mini-Miranda, the subsequent part of the Mini-Miranda, because it would be subsequent communications, whether they would require that it needs to come from a debt collector. So Milkovich is a case that left that open to interpretation to actually possibly have to put that in every document filed in court after the complaint and answer.
The next common violation we've seen, or alleged violation, involves the identity of the creditor. It's the failure to properly identify the creditor. This is a very popular claim now. Probably for the last 2 years or so, we've seen many cases coming out of various district courts and circuit courts addressing this issue. For something that seems relatively simple, just like the FDCPA as a whole, it's simple but not quite that simple when you implement it, because there are many creative plaintiffs' lawyers out there who will work around with your letter and assess if you comply with the requirement of 1692G2. 1692G is a validation notice requirement, and it only applies in the very first letter or the initial collection letter that you send out. 1692G2 specifically says that you are required to put down or identify the name of the creditor to whom the debt is owed. Now, the question is, how do you properly identify the creditor? Should it be the current creditor, or should it be the original creditor? That's one. Another is, do you even have to use the word creditor, or is it sufficient to just put down the name of your client, or your creditor client, that is? That, believe it or not, has been the subject of a lot of litigation recently with respect to the initial letter. Now, if they allege a G violation, they will also typically allege an E violation, which is the false or misleading representation subsection of the FDCPA. And what they typically argue here is that the failure to properly identify the creditor is in and of itself misleading. And the E violation just doesn't apply to the initial letter. It can also be triggered by subsequent letter to use. What do I mean? So you may not need the G validation language in your initial letter. And what I mean by validation language is the language that says, you have a right to dispute the debt, and you put down, the balance, the name of the creditor. You fulfill all the requirements of G. So you may not need to have the validation notice requirement in your subsequent letter. But if you do not properly identify the creditor, you may still be subject to an E claim, because it's misleading. The argument is it's misleading because you didn't tell us who we really owe the debt to. So in the recent, the last year or so, this particular issue has been very active in the Second Circuit, and what I mean by that, the New York courts. So, for example, if you have a collection letter, it has your letterhead on top, and then on your ray line, you have the name of the creditor. It could be a credit card company, or a cellular phone. Could be a medical debt, a hospital or medical provider. You have that on the ray line. You could even put down, for example, original creditor. If it's, let's say, it's originally an American Express card, and then the current creditor was the debt buyer, whoever that is, you have it there. Believe it or not, you can still be subject to this type of claim because the allegation is, well, you only mentioned the name of the creditor once. So it's not clear from the letter whether I meaning the consumer, I owe American Express or I owe ABC Collection Company. So it's not clear, therefore, who the creditor actually is. And that, believe it or not, has been the subject of a lot of lawsuits in the last 15 months or so. And the courts are split. Some courts say you got to read the letter as a whole. And if it's clear that, American Express is the creditor and the collection company is simply the collector because of the Mini-Miranda language, for example, you have a notice there that we are a debt collector, then taken as a whole, the least sophisticated consumer will not be confused by this letter, and it's okay. And we've seen those decisions in different parts of the country. We've seen it in Florida. We've seen it in New York too, notwithstanding the district court splits. That's fine. There are increasingly other courts that have said, well, no, that's a violation because you only mention it once, the name of the creditor, and the least sophisticated consumer could be misled. And some courts have actually looked at the payment slip that they tear off at the bottom, and if that payment slip directs the consumer to pay the collector, there has been a violation. At least one court has held that's a violation of the FDCPA because it's confusing who the creditor is if the consumer is making a payment to the collector, notwithstanding that it really goes towards the payment of their debt with the creditor. So be quite careful in identifying who you are, who you're collecting for, and who the current creditor is and the original creditor. If you cover all of that, chances are that you will have a more defensible claim against this type of violation. Other claims involving this improperly identified creditor involves the use of trade names. So, for example, if you say there that the current creditor is American Express, there have been lawsuits that say, well, not quite sure which American Express I owe. Is it this subsidiary of American Express or that subsidiary of American Express? So therefore, this letter is misleading. Well, the good news is for the defense bar that many courts have said a trade name, a commonly used name, is fine. So if you simply say there American Express or Amex or Chase or Sprint, and those are commonly used brand names, then it is not a violation of the FDCPA. It qualifies as a proper identification of the creditor. So that's one of the more common claims we've seen. And the next one, and if you have any questions, we'll take them at the end of this presentation. This is another one, inadvertent disclosure to third parties, and this happens either on a letter or by telephone. And I'll explain how we've seen this. So this is typically under 1692C. A collector is not allowed to disclose the existence of a debt or the details of a debt to a third party or somebody other than the debtor. The exceptions are obviously that you could disclose that to the consumer's attorney if they're represented, the creditor's attorney, debt collector's attorney, consumer reporting agency, of course, they're all part of the industry, so you could disclose that information. The one exception too is that if you are looking to confirm the address of the consumer, you may do that. That is an exception to this rule, but you can only do it once. You may call a non-consumer to verify their address or employment. That's what's called, that qualifies as a location information, and that is allowed under the FDCPA. So the most common claims we've seen, as I said earlier, involve phone calls. That is, and the question is, do you leave a message if you get a voicemail or an answering machine? Because typically what the practice we've seen is that the phone rings, the answering machine kicks in, you leave a message, and some collectors do leave the Mini-Miranda. Some collectors actually leave a message saying that this is ABC company, we're calling for Connie Montoya. If you are not Connie Montoya, hang up. Or it says we'll give you 3 seconds, and if you continue to remain on the phone, then we're going to assume that you are Connie Montoya. And so they proceed and give their details. That's no good. Even a message like that has been struck down by courts around the country, and the better practice we have found out is simply hang up. Hang up the phone, don't leave a message, but also be careful that you do not call or hang up repeatedly, especially in a given day, many times a day, or many times in a week, because then if you do that, you will be subject to another type of violation, which is under 1692D, as in David, which would be the harassment subsection of the FDCPA. And the allegation frequently is, I get too many hang-ups, or I get too many unanswered clicks in my voicemail or in my answering machine, and that's considered harassment. That's a claim. So just be careful of that. Make sure that when you do make phone calls and you do not leave messages, that your phone logs will reflect a pattern of calling that does not amount to harassment. You call once a day or less than 3 times a week or something like that, where courts, you could argue before the judge that this is not harassment. With respect to letters, what we have seen is, before I go into letters, the other thing is calling a represented party. If you get a letter from a consumer attorney, you cannot call that consumer anymore. You have to direct all your calls to the legal representative of the consumer. If you get a cease and desist, you also must stop communicating with that consumer. The one thing we've been seeing, another pattern we've been seeing, is when consumers work with debt management representatives. We've seen this. There's been a persistent case filed by a specific plaintiff's attorney where they would send out numerous faxes to different collectors saying that I have a power of attorney, I am writing on behalf of this consumer, I am disputing the debt, and you should mark your credit reports as disputed. And then after they do that, they would then, after a few days, would call the collection company saying, I am the authorized representative of so-and-so, we sent you a power of attorney, and I'd like to dispute the debt. And the collector at that point would typically give information like, I'd like you to verify this with me, is your social security XYZ, do you live at this address, what the collector typically goes through. And then that's when the lawsuit is filed for 2 reasons. One is you didn't quite verify, you disclosed information, you didn't have proof that I was the authorized representative. That's one allegation. The other allegation is that's for the unauthorized disclosure. The other is sometimes they come up with failure to properly notate the account that is disputed when a telephone call is made. So the better practice in that is for your collector, if you do get that call, if they say that a power of attorney has been sent, to look at the notes, and if it doesn't reflect, the account notes don't reflect that it has been received, then say, cannot speak to you, we do not have a record of the power of attorney, please resend it and call us back, or just say we would really like the consumer to be on the line so that they can confirm that you are the authorized representative for them. That typically is when you've raised those defenses before the court, we've had favorable results. With respect to letters, this is a fading claim now and came out of the Third Circuit decision called the Douglas case, where in letters there's a glassine window that has a barcode or one of those, I forget the name, it's a box that you could scan, and when you do scan that box, the account information for the consumer will appear. That has been held to be an improper disclosure of account information to non-consumers and violates the FDCPA. That Third Circuit decision came out, I believe, in 2015, if not 2016, and the year immediately thereafter, there's been a spawn of different claims. But as a result of that decision, however, a lot of collectors have since changed their practices and removed the barcodes or that QR box from their letters. And so that particular claim has decreased significantly throughout the country. All right, so that's the improper disclosure violation that we've seen frequently. Okay, I'm on a roll here. Here's my before you hear from Barbara again, this is like my last topic, which is the disclosure of account balances. That is, I think, the red-hot topic of the year, or at least of 2017 spilling over into 2018. And we believe that it's just going to continue because the courts, there's a circuit split. There's many circuits that are split on this issue, as well as district court splits, because nobody knows what to do anymore. Before 2016, the debt collection industry was pretty safe, I would say, pardon the pun, with the safe harbor language, which was issued by the Seventh Circuit in Miller versus McKayla. And the language you could see on this slide was used in thousands, if not millions of letters. That's with this, and I have it right here on the slide, it's this amount does not include accrued but unpaid interest, unpaid late charges, etc. And this is called the safe harbor language because it provides the collector with that defense, meaning if on this letter that we issue the balance is, let's say, $105.55, and we know that interest is accruing or late fees may be imposed, in other words, that balance is not static, then with this safe harbor language, a collector is immunized from the allegation that the balance that you provided in your collection letter is inaccurate. Now, in 2016, the Second Circuit came out with a decision called Avila versus Rexinger and Associates. And the Second Circuit at that point formally adopted the Miller safe harbor language for cases filed within the Second Circuit of New York. In that case, the issue was relatively simple. The collection letter did not have the safe harbor language, and the balance was in fact increasing. So the court formally adopted Miller. The problem was how Avila then was interpreted by its progeny, or a bunch of different district courts, not just in New York, but throughout the country. And this is where the problem started coming up. It was when you use the safe harbor language, but the balance itself changed, but did not change. And here's what I'm saying. Here's what I mean. The situation is where the charge off balance is in fact subject to interest, but the creditor, your client, has chosen not to collect it. So what the plaintiff's bar has been arguing is that even if you have the Michaela safe harbor language or the Miller safe harbor language, but the balance is subject to increase at some point, there may be a violation right there. So that is where the courts are now split. It's not entirely clear where they're going. To give you another example, these are letters that say, here's the balance, $105. Total interest is zero. Okay, so total amount, and then you have language like total amount of interest accrued since charge off is zero. But then you have the safe harbor language anyway in your letter, because you know that at some point that the loan itself is still accruing interest, only that your client decided not to charge it. But if, let's say, that debt is passed on to another collector, or another debt buyer purchases it, that balance may well change because they are entitled under the credit agreement to accrued interest. So what happens then? And that's a question that really has not been resolved by the courts in a definitive way. There is a pending decision before the Second Circuit called Taylor versus Financial Recovery, which specifically confronts this issue. But as I said, that decision has not been out yet, and we're waiting for it to come out. It should be out this year. Oral argument was held earlier this year, early in January, I believe. And so we should have a decision soon, and I'm sure it will impact the industry. So be clear. I guess the takeaway there is only collect what is legally due and owing. Use the safe harbor if, in fact, the balance is bound to change. Do not add language like zero interest at this point or as of the date of this letter if you know that interest is still subject to accrual. And until we get the Second Circuit with more Second Circuit decision and Taylor with more guidance, I think we have to just wait and see.
Now we're going to jump to number 5, which involves processing fees. So this falls under Section 1692F1 of the FDCPA, which specifically prohibits collection of any fee or expense that's incidental to the principal amount unless it's authorized by agreement, by the underlying contract, or by law. We've also seen this alleged under 1692E in terms of it being a false and misleading statement, if you will, if a notice says that defendant is entitled to recover such a fee. So what fees are we talking about? What is a processing fee? So normally what happens is that a lot of collection agencies are using what's called either a processing fee or a credit card fee. Some refer to it as a convenience fee, which is a couple of things. When a debtor pays by credit card or by debit card on the web or by the phone, a processing fee may be charged. In terms of, let's say, you get a letter and it says if you want to pay online, visit such and such website. You'll be charged $3.95 to pay via the website. That's a processing fee. It's basically the cost of using that website and having a vendor process that payment. A lot of collectors use this, and there has been a lot of litigation over it because plaintiffs' attorneys have brought lawsuits basically saying that such a fee is either a violation of F1 or is false and misleading under E2. So what to look at? One of the most important things to do as the collector is read the underlying credit agreement of the client before deciding to use a processing fee. Make sure that that is something that you are authorized to do per the contract. 2, it's important to read state law. There's states that have specific laws prohibiting such types of processing fees or credit card fees or a percentage of the principal amount. So that's very important to look at, and also look from state to state because your company may be collecting in either all 50 states or just various states, so you have to be privy to what state laws say on this issue where you're sending letters collecting debts. Now, well, there's a couple of defenses, right, when faced with one of these claims, which is, 1, is the fee incidental or not to the debt? Now, courts are split on this issue. Some courts have said that it's not incidental because it adds nothing to the principal amount. Other courts have differed, so that you'll have to see in terms of where you're sued on that. Another defense is the pass-through defense. What does that mean? So courts have looked at when there's a third-party vendor that's collecting the processing fee in order to basically process these payments. If the third-party vendor is collecting the entire processing fee, the entire fee goes to the vendor, then that's called the pass-through defense, meaning that it's not a collection. The debt collector is not necessarily collecting that fee. It's the vendor. So the vendor is collecting that fee for purposes of processing this payment. The debtor is choosing to pay via a website or any kind of electronic manner, choosing to pay with a credit card, whatever it may be. And if the vendor is collecting 100% of that fee for the process of it, then there is a defense that that is not collection under 1692 F1. And another defense that's also popped up is lack of standing, meaning, yes, the consumer received this letter, but did they actually use the process to pay via email, and were you actually charged that fee? So receipt of the letter alone is not enough. It doesn't create harm for you to receive a letter that says you'll be charged this processing fee if you pay online. You actually have had to avail yourself of that service, paid it through the website, and actually been charged that fee and paid the fee. So those are all the issues that come up when using or charging processing fees, and so it is something to keep in mind when you're using that service. Okay, number 6, harassing phone calls. This falls under 1692D of the FDCPA, which covers harassment, and the section says a debt collector may not cause a telephone to ring or engage in any person in telephone conversation repeatedly or continuously with the intent to annoy, abuse, or harass any person at the called number. I mean, just reading that alone, you can tell that it's a subjective standard. I mean, what does it mean to to make the phone ring in a way that that's repeated or continuously, how there needs to be intent to annoy or not. So this is definitely something that is looked on a case-by-case basis. Under 692C, which also involves phone calls, a debt collector shall only call a consumer after 8 a.m. and before 9 p.m., local time at the consumer's location. Now, this sounds pretty straightforward, but what ends up happening is that, as we all know, cell phone numbers are very portable these days, and somebody who resides in the East Coast could certainly have a phone number that has an area code from the West Coast, so it's hard to keep track of the time zones that you're in order to make sure that you comply with that statute, but that is something to keep in mind. We don't see these claims that much, but it is something that needs to be followed and complied with by all debt collectors that fall under the FDCPA. More on harassing phone calls. So how much is too much? What is harassing? Like I said, it's subjective. It's case by case. And here are some examples, two of which are in Florida. For instance, in Tucker, court held that debt collector who calls 57 times, often calling 7 times per day and leaving 6 identical voice messages, did not violate 1692D. The court found it was not harassing. Another court in the Middle District of Florida, summary judgment in favor of debt collector, 132 calls during 9 months, 29 times in a single month, and often called 4 times a day. That court still said it wasn't harassing. And then the next case, 49 calls in 18 days was not egregious. Collector waited at least 90 minutes between each call and made no more than 5 calls in a single day. So again, it's subjective. It's going to be a case-by-case on a case-by-case basis. But what I've seen most of all is that if the calls are generally separated, if they're separated in time, meaning not so much in time such as this whole 90-minute gap, and again, that's not a bright line rule, it's just an example, and also in time in the sense of has it spans through 8, 9 months, 10 months, usually courts will say that's not harassing if the consumer did not pick up the phone and say, stop calling me, or I'm not going to talk to you, I'm not going to pay this debt. When something like that happens and calls continue afterwards, then courts will usually say that that is harassing, because at that point somebody has answered the phone and said, I don't want you to call me anymore, I don't want you I'm not going to pay this debt. So the fact that a collector would keep calling afterwards could be considered harassment and probably will be considered by harassment. Will be considered as harassment. So the takeaway with phone calls and quote-unquote harassing phone calls is, it involves almost like a common sense. If you reach a collector that says they don't want to talk to you anymore, stop calling me, I'm not going to pay, you should stop calls. One of the most risk adverse approaches would be just don't leave messages. That's another. I know most collectors do, but some courts have said you don't want debt collector, you do not want to be found liable for leaving such a message or what's in your message. Then don't leave a message. You're not entitled to leave a message under the law. It's not something that's been given to you that's a must. You can choose not to leave messages. So that's also an approach that some debt collectors take when they know that they're calling in areas that are hotbeds for litigation, such as Florida, such as New York, such as Chicago. Okay. Let's jump to number 7, oral versus written disputes, and what is the proper way. This falls under 1692C, which states that if a consumer notifies a debt collector in writing, and now that in writing is emphasized because that's exactly what the statute says. It says in writing that the consumer refuses to pay a debt or wishes collector to cease further communication, then the collector must not communicate with that consumer anymore, except for 2 things: to let the consumer know that collection efforts are terminated, and 2, to notify the consumer that the collector or the creditor may invoke specified remedies, such as whatever it may be, credit reporting, filing a lawsuit, foreclosure proceedings, garnishing wages, whatever it may be. You can notify the consumer that may happen. But after that, you cannot communicate with that consumer any longer. So best practice is, and I mentioned that with the harassing calls, which is even if you get a cease and desist communication, whether it's stop calling me, I'm not going to pay this debt, verbally on a phone call, you should stop calling. Why? Because even though 1692C says in writing, and it might not be a violation of this section, it could potentially be a violation of 1692D because courts have said that that constitutes harassment because of the fact that the debt collector has been put on notice that the consumer wanted calls to stop, but they continued.
So the other violation involves debt settlement offers. And this typically touches on two issues. One is collecting on time-barred debt or offering to settle time-barred debts. And the other is language involving tax consequences. So I'll talk about the time-barred debt issue first. And that's typically it arises in states where it is okay under state law to collect on time-barred debt because just because a debt is time-barred doesn't mean that it's no longer enforceable, that it's written off. It doesn't mean that. What it means, though, is that you cannot file a lawsuit, a collection lawsuit, on a time-barred debt. So that's under state law. So then what happened, or when these claims started coming out, the courts were initially saying, well, if the state law allows collection on a time-barred debt, there can be no violation of the FDCPA so long as the threat of litigation or litigation or threat of litigation is non-existent, or there's no or litigation hasn't been started at all. So that was the common position by many courts. Then as of late, there's a recent decision in the Third Circuit called Tatis versus Allied Interstate. Very recent, it just came out in February, last month, February 12th. And the Third Circuit there said, you know, even if you do not threaten litigation, the letter can still be misleading and therefore a violation of 1692E because the word settlement and settlement offer in and of itself connote litigation. That's a big change because now the courts are saying, you know, although it's okay for you to collect and you're not threatening litigation, you may still be subject to a misleading or false misrepresentation violation when you use the word settlement or settlement offer. So that's a very recent decision. We don't know how how the other courts are gonna spill out on that. And it's reminiscent of another circuit decision by this time it's the Seventh Circuit. That case is Pantoja, Pantoja versus Portfolio Recovery Associates. That decision was issued a year ago, March 2017, and it said there that the letter violated the FDCPA because it wasn't clear at all. It wasn't clear from the letter that the debt they were collecting is time-barred. So this is a different variation of the Tatis case. In the Tatis case, the letter did say that there was an indication that it's time-barred, but we're not going to sue you. But if you but we're still making a settlement offer. So that's the New Jersey letter. In the Illinois letter, in the Seventh Circuit letter, the letter didn't even make any mention of any time-barred debt at all. And that, the court was very clear. You can't do that. You cannot even, your letter, if you're collecting on a time-barred debt, must somehow advise the consumer that the debt is time-barred. So be careful when you are sending out letters involving time-barred debts. The common policy that the courts are protecting is the gullible consumer who makes a partial payment on a debt and the whole debt is then revived. That's really the issue. Because even though a debt is time-barred, once payment is made, and even a partial payment at that, then the whole defense of statute of limitations is gone. Because then the whole debt is, basically the debt is reset. It starts a whole new statute of limitations. And the courts are saying, protecting the fact that the consumer would have been better off by not making any payment at all had they known that. And if you had advised them if you had not mentioned that at all, then you basically misled them or deprived them of that defense. So that's the warning bell when it comes to settlement offers involving time-barred debts. The other issue we've seen involves the tax consequences or 1099-C language. What does that mean? In settlement offer letters, we've seen a lot of letters that say if the settlement is $600 or less, then or $600 or more, there may be tax consequences. Or if the settlement is $600 or more, the creditor is obligated to report to the IRS. And consumers have come up claiming that the language about filings of 1099-Cs or language concerning tax consequences is confusing, especially when that requirement to the reporting requirements to the IRS won't even be triggered because the settlement or the value of the settlement being offered is below $600. So the typical claim there is that even if you have the language of having tax consequences, for example, you have, this settlement of this letter may have tax consequences, please consult your tax advisor. There are courts who've said, well, that's misleading, especially if the settlement is way below $600 and this requirement will never be triggered. But some courts have said, no, it's not a violation of the FDCPA, particularly because when letters use the word may have tax consequences, it basically the least sophisticated consumer is advised that it may or it may not happen. So therefore, it's immaterial whether or not the filing requirement is triggered because it may or may not happen, and that's not misleading. So there are courts in Connecticut and in Wisconsin that have said that's not a violation of the FDCPA, but there are other courts that, especially in Pennsylvania, and also in some district courts in New York, have said that it can well be a violation of the FDCPA. So be very careful about how you phrase or how you use the filing requirements or tax consequences language in your letter. Double check the balances or the settlement offers if in fact the filing requirement will be triggered or not. Very important that you consult with your attorney, your collection attorney, or your FDCPA attorney for compliance with the law. This is still a changing area of FDCPA compliance, and given the splits by the courts, it may well depend on which jurisdiction you're collecting.
So number 9 is attorney involvement in debt collection. This comes in when actual lawyers are in the business of debt collection, and they're sending letters out with their letterhead and making collection efforts and collection communications through a law firm because they're lawyers and this is what they do. So whether an attorney's lack of meaningful involvement, quote unquote, in the collection process violates the FDCPA really depends on the facts and circumstances of every case. Courts have looked at this because when a complaint is signed by an attorney, not only is that attorney involved, but that attorney has assumes the least sophisticated consumer would believe that that attorney has had a certain level of involvement in that case. That's what courts have found. So a lot of times what happens is that the court will look at what the letter states, and if a lawyer signed it, they're going to hold the lawyer accountable as a debt collector because of the fact that they've made that representation. So when you're using a letterhead, there's another implication, which is courts have found that the use of an attorney letterhead and signature by the collection agency, which is a law firm, even if the attorney had no personal involvement in sending out the letter, is a violation. So courts have found that to be misleading under 1692E. Other courts have said, and that's what a lot of law firms have done, is that if you enter a disclaimer within that letter, a disclaimer that says, no attorney has reviewed the file, but there's still a letterhead and there's still either a signature or an attorney name, then there's no violation, because now, and that's a Second Circuit case in Greco, now that's shown that there is, you've put the consumer on notice that this particular lawyer or a lawyer has not had a meaningful involvement in the collection of that file. And then we'll jump to the last one, number 10, threat to sue or threat to take legal action that cannot be taken. This is a common claim in FDCPA litigation, and basically it falls under E5. It's a violation to threaten to take any action that cannot legally be taken or that is not intended to be taken. That's how the statute reads. So what does the court look at, and what are we talking about here? Usually you'll find this when there's a letter that says something to the effect of a collector or creditor will take any action available under law, or may take any available action under law. Some letters even say, if we don't hear from you within 3 days, we may file a lawsuit. We may garnish your wages. Those type of statements is what covers these claims and this section. So what the court looks at is whether the language of the letter constitutes, number one, they first look at whether the language constitutes a threat for the purposes of E5. And two, if it does, whether the action threatened is one which could be legally taken. And one of the seminal cases in regards to this section was Jeter from 1985 from the 11th Circuit, which is cited there. And then after that, there's also another 11th Circuit case that covered this called LeBlanc. And in that case, the issue was failure to register as a debt collector within the state, and the fact that you're sending this letter when you're not licensed could potentially be a threat to take an action that cannot legally be taken, because legally you're not supposed to be collecting debt since you're not registered in the state. So that's what LeBlanc looked at. And what LeBlanc also looked at was whether it's a threat needs to be looked at first, whether the statement or the letter as it's on its own is a threat. LeBlanc also said that sometimes, depending on the statement that's included in the letter, sometimes that's a jury issue, and that needs to be left, it's an issue of fact and needs to be left for the jury to decide whether it's a threat or not. Now, keep in mind that just adding the word may or if is not enough to remove the overall threatening nature of a statement in a letter. A letter could potentially say, you may go to jail if you don't pay this, and that doesn't make it less threatening just because you put may. So keep that in mind. The takeaway is don't add any statements in your letter that you're going to potentially do something when you, number one, do not have the authority to do it, and number two, if you don't intend to do it or if you've never done it. I have a case right now where a debt collector was sued because the letter says something to the effect of, we will use any and all legal action possible, but because they've never filed a lawsuit, then that could be a problem. They have the authority to do it, but maybe they haven't done it or whatnot. So keep in mind what you include in your letters and make sure that whatever statements are in there, you do have authority to do and you do intend to do, because that could fall into, unfortunately, a violation of the FDCPA.
The FDCPA, as I said, is a fast-growing, developing statute. There's been an increase of litigation and investigations by federal and state agencies, which is regarding collection laws that implicated by the FDCPA. So it's really important that not only do you have your letters reviewed by a compliance counsel, but also that they get reviewed more than once a year, given the changing landscape of the law.